Annulment of marriage or declaration of nullity. First case. GR number 162368. Ma. ARMIDA PEREZ-FERRARIS, petitioner, versus BRIX FERRARIS, respondent. Facts. ARMIDA and BRIX are a showbiz couple. The couple's relationship, before the marriage and even during their brief union, for well about a year or so, was not all bad. During that relatively short period of time, ARMIDA was happy and contented with her life in the company of BRIX. ARMIDA even admits that BRIX was a responsible and loving husband. Their problems began when ARMIDA started doubting BRIX's fidelity. It was only when they started fighting about the calls from women that BRIX began to withdraw into his shell and corner, and failed to perform his so-called marital obligations. BRIX could not understand ARMIDA's lack of trust in him and her constant naggings. He thought her suspicions irrational. BRIX could not relate to her anger, temper and jealousy. ARMIDA presented a psychological expert, Dr. Diane, who finds BRIX to be a schizoid and a dependent and avoidant type. This is evidenced by BRIX's leaving the house attitude whenever they quarreled, the violent tendencies during attacks, the sexual infidelity, the abandonment and lack of support, and his preference to spend more time with his bandmates than his family. Issue: whether or not psychological incapacity is attendant in the case at bar. Held. The Supreme Court upheld the decision of the lower courts. The alleged mixed personality disorder, the leaving the house attitude whenever they quarreled, the violent tendencies during epileptic attacks, the sexual infidelity, the abandonment and lack of support, and his preference to spend more time with his bandmates than his family, are not rooted on some debilitating psychological condition, but a mere refusal or unwillingness to assume the essential obligations of marriage, and these do not constitute psychological incapacity. Further, the expert was not able to prove her findings. Notably, when asked as to the root cause of respondent's alleged psychological incapacity, Dr. Diane's answer was vague, evasive and inconclusive. She replied that such disorder can be part of his family upbringing. She stated that there was a history of BRIX's parents having difficulties in their relationship. This is of course inconclusive, for such has no direct bearing to the case at bar. Second case. Leonilo Antonio versus Marie Yvonne F. Reyes. Facts. Antonio and Reyes first got married at Manila City Hall and subsequently in church on December 8, 1990. A child was born in April 1991 but died 5 months later. Antonio could no longer take her constant lying, insecurities and jealousies over him, so he separated from her in August 1991. He attempted reconciliation, but since her behavior did not change, he finally left her for good in November 1991. Only after their marriage that he learned about her child with another man. He then filed a petition in 1993 to have his marriage with Reyes declared null and void under Article 36 of the Family Code. The trial court gave credence to Antonio's evidence and thus declared the marriage null and void. Court of Appeals reversed the trial court's decision. It held that the totality of evidence presented was insufficient to establish Reyes' psychological incapacity. It declared that the requirements in the 1997 MOLINA case had not been satisfied. Issue: whether or not Antonio has established his cause of action for declaration of nullity under Article 36 of the Family Code and, generally, under the MOLINA guidelines. Held: yes. The petitioner, aside from his own testimony, presented a psychiatrist and clinical psychologist who attested that constant lying and extreme jealousy of Reyes is abnormal and pathological, and corroborated his allegations on his wife's behavior, which amounts to psychological incapacity. The factual findings of the trial court are deemed binding on the SC, owing to the great weight accorded to the opinion of the primary trier of facts. As such, it must be considered that respondent had consistently lied about many material aspects as to her character and personality. Her fantastic ability to invent and fabricate stories and personalities enabled her to live in a world of make-believe. This made her psychologically incapacitated, as it rendered her incapable of giving meaning and significance to her marriage. Third case: LEOUEL-SANTOS versus Court of Appeals and Julia Rosario BEDIA-SANTOS. Facts: LEOUEL, a first lieutenant of the Philippine Army, married Julia in a municipal trial court and thereafter, in a church. She gave birth to a baby boy and was named LEOUEL Jr. Occasionally, the couple quarreled over a lot of things, including the interference of Julia's parents into their family affairs. Julia went to US to work as a nurse and promised husband that she will return once her contract will expired. She never did. LEOUEL tried to find her in the US, but somehow failed to contact her or get in touch with her. LEOUEL filed a petition to have their marriage declared null and void, citing Article 36 of the Family Code. He argued that Julia's failure to return home and communicating with him for more than 5 years constitutes psychological incapacity. Issue: whether or not their marriage can be considered void under Article 36 of the Family Code. Held: no. Julia's failure to return to her husband and communication with him do not constitute psychological incapacity. The intendment of the law has been to confine the meaning of psychological incapacity to the most serious cases of personality disorders, clearly demonstrative of an utter insensitivity or inability to give meaning and significance to the marriage. This psychological condition must exist at the time the marriage is celebrated. Psychological incapacity must be characterized by a. juridical antecedents, b. gravity, and c. incurability. In the case at bar, although LEOUEL stands aggrieved, his petition must be dismissed because the alleged psychological incapacity of his wife is not clearly shown by the factual settings presented. The factual settings do not come close to the standard required to decree a nullity of marriage. Fourth case: MING versus Court of Appeals and GINA LA-TSOI. Facts. MING-TSOI and GINA LEOUEL was married in 1988. After the celebration of their wedding, they proceed to the house of defendant's mother. There was no sexual intercourse between them during their first night, and same thing happened until their fourth night. In an effort to have their honeymoon in a private place, they went to Baguio, but Gina's relatives went with them. Again, there was no sexual intercourse since the defendant avoided by taking a long walk during siesta or sleeping on a rocking chair at the living room. Since May 1988 until March 1989, they slept together in the same bed, but no attempt of sexual intercourse between them. Because of this, they submitted themselves for medical examination to a urologist in Chinese General Hospital in 1989. The result of the physical examination of Gina was disclosed, while that of the husband was kept confidential, even the medicine prescribed. There were allegations that the reason why MING-TSOI married her is to maintain his residency status here in the country. Gina does not want to reconcile with MING-TSOI and want their marriage declared void on the ground of psychological incapacity. On the other hand, the latter does not want to have their marriage annulled because he loves her very much. He has no defect on his part and is physically and psychologically capable, and since their relationship is still young, they can still overcome their differences. MING-TSOI submitted himself to another physical examination, and the result was there is not evidence of impotency, and he is capable of erection. Issue: whether MING-TSOI's refusal to have sexual intercourse with his wife constitutes psychological incapacity. Held. The abnormal reluctance or unwillingness to consummate his marriage is strongly indicative of a serious personality disorder which, to the mind of the Supreme Court, clearly demonstrates an utter insensitivity or inability to give meaning and significance to the marriage within the meaning of Article 36 of the Family Code. If a spouse, although physically capable but simply refuses to perform his or her essential marital obligations, and the refusal is senseless and constant, Catholic marriage tribunals attribute the causes to psychological incapacity than to stubborn refusal. Furthermore, one of the essential marital obligations under the Family Code is to procreate children. Thus, constant non-fulfillment of this obligation will finally destroy the integrity and wholeness of the marriage. Fifth case: Republic of the Philippines versus Court of Appeals and RORIDEL OLAVIANO MOLINA. Facts. The case at bar challenges the decision of C affirming the marriage of the respondent RORIDEL Molina to Reynaldo Molina void in the ground of psychological incapacity. The couple got married in 1985. After a year, Reynaldo manifested signs of immaturity and irresponsibility both as husband and a father, preferring to spend more time with friends whom he squandered his money, depends on his parents for aid and assistance, and was never honest with his wife in regard to their finances. In 1986, the couple had an intense quarrel, and as a result their relationship was estranged. RORIDEL quit her work and went to live with her parents in Baguio City in 1987, and a few weeks later, Reynaldo left her and their child. Since then, he abandoned them. Issue: whether or not the marriage is void on the ground of psychological incapacity. Held: the marriage between RORIDEL and RONALDO subsists and remains valid. What constitutes psychological incapacity is not mere showing of irreconcilable differences and conflict-ion personalities. It is indispensable that the parties must exhibit inclinations which would not meet the essential marital responsibilities and duties due to some psychological illness. Ronaldo's action at the time of the marriage did not manifest such characteristics that would comprise grounds for psychological incapacity. The evidence shown by RORIDEL merely showed that she and her husband cannot get along with each other and had not shown gravity of the problem, neither its juridical antecedents nor its incurability. In addition, the expert testimony by Dr. Sisson showed no incurable psychiatric disorder, but only incompatibility, which is not considered as psychological incapacity. The following are the guidelines as to the grounds of psychological incapacity laid set forth in this case. A burden of proof to show nullity belongs to the plaintiff. B. Root causes of the incapacity must be medically and clinically inclined. C. Such incapacity should be in existence at the time of the marriage. D. Such incapacity must be grave so as to disable the person in complying with that. E. Essentials of marital obligations of marriage. F. Such incapacity must be embraced in Art. 68 to 71, as well as Art 220, 221, and 225 of the Family Code. G. Decision of the National Matrimonial Appellate Court or the Catholic Church must be respected. H. Court shall order the prosecuting attorney and the fiscal assigned to it to act on behalf of the state.